Okay, we're ready with Mr. Adams and Crystal Barnes.
All right, and Ms. Tabriam, can you move that camera up? I'd like to see Mr. Adams eye to eye. I'll make sure we meet eye to eye on things. Mr. Adams, you just get down on your knees, sir. We're gonna do this plea with you sitting on the floor. There we go.
How's that, Your Honor?
That's better. Thank you. All right, Ms. Barnes, if you will, raise your right hand. I'm gonna place you under oath. Ms. Barnes, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. It's going to be real hard for us to hear you, so you're going to have to speak up loudly and clearly so my court reporter who's here in the courtroom can take down everything we say, okay?
Okay.
That's better. Thank you. All right, your name is Crystal Lynn Barnes, right?
Yes, Your Honor.
And Ms. Barnes, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
And have you ever been diagnosed with any type of mental condition?
Yes, sir. I have PTSD and bipolar.
Are you currently on any medications for PTSD or bipolar?
Yes,
You
sir.
are?
I'm on it. Yes, sir.
Okay. Okay. And do you feel like those medications are helping you and giving you the ability to rationally understand everything that's going on here today?
Yes, sir.
All right. Thank you. You're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed with Mr. Adams that you do not understand?
No, I understand it all.
Good. Thank you, Ms. Barnes. Mr. Adams, do you believe Ms. Barnes to be competent today?
I do, Your Honor. She's competent.
And you've explained to her her legal and constitutional rights?
That's correct.
Ms. Barnes, you are charged by indictment with a third-degree felony offense of credit card or debit card abuse. That carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC and a fine not to exceed $10,000. Any sentence handed down by this court or a jury must fit within that range of punishment. I see here today that you want to enter into a plea agreement with the state of Texas, wherein you would be pleading guilty in exchange for their recommendation of 3-year sentence and a $2,500 fine plus court costs and reimbursement fees, with you receiving a jail credit for time that you have spent in jail of 132 days. Is that your understanding of the plea agreement?
Yes, Your Honor.
Yours as well, Mr. Adams?
That's correct, Your Honor.
All right. Ms. Barnes, then understanding the full range of punishment, how do you plead to the third-degree felony offense of credit card or debit card abuse against the elderly?
Guilty. Guilty.
And Ms. Barnes, are you pleading guilty to that charge because you are in fact guilty of committing that charge?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Adams, any objection to states one?
No objection, Your Honor.
All right, states one's admitted into evidence, and the court will take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
I'm thinking of the appropriate time to bring it. Not at this point, Your Honor.
Okay. I'm gonna take just a moment and review the evidence. All right, based on the court's review of the evidence, I do find that there is sufficient evidence to convict Ms. Barnes of this offense. Before I do so, though, I'd like to inquire with the state with regards to restitution. Is there no restitution claimed by the credit card or bank that had to pay the fees, or the victim in this case?
Let me look, Judge. Judge, it appears as though we sent a victim impact statement along with a restitution form, and that was not returned by anyone to our office. So we have no information as to any claims for restitution at this point.
Was that sent to the financial institution or only to the alleged victim?
I believe it appears it was sent to the victim who has Alzheimer's, and also to I believe it's the victim's niece who has power of attorney. But I don't see that we have ever reached out to a financial institution regarding the credit card or any outstanding fees or anything.
Okay. Okay. All right, Ms. Barnes, then based on the evidence before the court will find you guilty of this third-degree felony offense of credit card or debit card abuse against the elderly. The court will follow the plea agreement, assesses your punishment at 3 years confinement in Texas Department of Criminal Justice, assesses a $2,500 fine, orders you to pay reimbursement fees of $70 and court cost of $290. Court will award you 132 days credit for the time that you have spent in jail on this cause. Mr. Adams, did you have something you wanted to bring to the court's attention?
Yes, Your Honor, the lieutenant here made it a point to approach me as Ms. Barnes and I were meeting this afternoon to inform me that she's been very instrumental and effective in assisting with the Scared Straight program here at the Van Zandt County Jail. The lieutenant wanted you to know that, and it's my understanding that when Ms. Barnes is finished serving her time in TDC and is released on parole sooner rather than later, we hope, she's going to return to the Van Zandt County Jail and further continue to assist the lieutenant with that program and dealing with those young people who find themselves here.
Well, that's great to hear, Ms. Barnes. I appreciate you being proactive while you're in custody and doing something productive and resourceful. And I hope that when you do get out, that you do return, because it's your experience and the reality of your experience that I think will carry a lot of weight to those who may be in your shoes or thinking about being in your shoes. So thank you for doing that. I do commend you for that.
Yes, if I can keep anybody from being where I'm at right now, I'll do it. I would hate to see my children in my position. So if I can help some young people, I'll do it.
Well, I do hope that that is a positive impact that comes out of this for you. So do commend you for doing that, and do hope that you come back in the future and help us with that work.
You have my word.
All right, good. Thank you, Ms. Barnes. All right, Ms. Barnes. So I'm going to hereby remand you to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over with the bailiff to be fingerprinted. Good luck to you.
Your Honor, that's all I have this afternoon. I'd excuse it.
Yes, thank you, Mr. Adams.
All right, thank you, ma'am.
Okay, Mr. Wood is ready on James King, who is going to be taking a plea.
Okay. All right, so Mr. Wood, you said Mr. King is going to be taking a plea today?
That's correct, Your Honor. The plea is for actually a lesser included offense of a Class A misdemeanor. Family violence. This case initially started off as an assault family violence ×2 that occurred within the span of 30 days, which is why it was enhanced to a felony. After negotiations and talks with the DA's office, they decided to abandon one of those assault cases, plead to a Class A misdemeanor, and we're ready to go forward on that today.
So what are the terms of the plea?
The plea is for, I think it's for 170.
Judge, it's 173 days in jail, credit for 173 days, fine of $1,500, which includes the $100 family violence fine, obviously a family violence finding, court costs of $270, attorney's fees of $975, reimbursement fees of $20. Obviously the I think I said, but $100 family violence fine and a fine of $1,400 general fine.
And that's our understanding. The plea as well.
And this is number CR 2345.
Yes, Judge.
And is there any other cases that Mr. King has that are being resolved today?
See if we have anything open. No, Judge, I believe that is all. There was a DA control number, DA 2020-0544, which was an assault family violence that has previously been taken into consideration by our office into creating the continuous violence against the family charge. But we are agreeing to, obviously, we're not going to reopen that at this time. So we would just proceed on this. And obviously that has already been resolved, but taken into consideration by our office. So we would obviously not prosecute further DA 2020-0544, which was already subsumed into CR 20-00345 in creating continuous violence against the family, which we are now waiving basically those allegations and just allowing Mr. King to plead to this one assault.
Okay, thank you. All right, Mr. King, if you will, raise your right hand, place you under oath. Mr. King, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Mr. King, are you a United States citizen?
Yes, sir.
And you do read, write, and speak English, right?
Yes, sir.
And have you ever been diagnosed with any type of,
PTSD?
are you currently on any type of medication or undergoing treatment for PTSD?
No, sir.
Do you feel like your disorder with you not being on medication or under treatment is in any way affecting your ability to rationally understand the proceedings that are being brought against you?
No, sir.
Okay. In this case, represented by your attorney, Mr. Jeff Wood, are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed and reviewed with Mr. Wood that you do not understand?
No, sir.
All right, Mr. Wood, do you believe Mr. King to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
I have.
All right, Mr. King, you were originally charged with a third-degree felony offense, but with the plea agreement being to a lesser included Class A misdemeanor of assault, family violence, cause bodily injury. The range of punishment for that charge is confinement in the county jail for a period not to exceed 365 days and a fine not to exceed $4,000. It means any sentence handed down by this court or a jury must fit within that range of punishment for that crime. I see here that based on what Mr. Woodwike and Mr. Wood have indicated as the plea agreement, that the plea agreement does fit within the range of punishment. So at this time, I'm going to ask you, how do you plead to the Class A misdemeanor offense of assault causes bodily injury, family violence?
Guilty.
Mr. King, are you pleading guilty to that charge because you are guilty of committing that charge?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Wood, any objection to States 1?
No objection, Your Honor.
States 1 is admitted in evidence, and the court takes judicial notice of Mr. King's judicial confession. Is there a victim impact statement or anything further from the state?
Judge, the state has nothing else. The victim was sent a victim impact statement. It has not been returned to our office. Additionally, we do also have an affidavit of non-prosecution in this charge from the victim that was filed with our office. That was instrumental in reaching this resolution.
All right, anything further from the defense?
Nothing further, Your Honor.
All right, Mr. Woodwike, can you give me a brief summation of the facts to support the plea?
On May 7th, 2020, at about 1 o'clock in the morning, Canton PD was dispatched to a female in the lobby of the police department that had been assaulted, made a police report. She identified her boyfriend, James King, as the man who did it. She had some bruising around her left and right eye. She informed the officer that Mr. King had assaulted her at the residence and occurred 15 to 20 minutes prior. There's a family violence packet, and they issued an emergency protective order.
All right, Mr. Wood, into that summation.
No, Your Honor.
All right, then based on the evidence presented to the court, I will find that the evidence does substantiate the guilt of Mr. King. The court will follow the plea agreement in this case, and court hereby convicts Mr. James King of the Class A misdemeanor offense of assault, family violence. Court does make a family violence finding. Court assesses his sentence at 173 days confinement in the Van Zandt County Jail. Court will award him 173 days credit for time that he has served on this case. Court assesses punishment at assesses a fine at $1,500, court costs at $270, orders reimbursement at $20, and orders him to reimburse Van Zandt County for indigent attorney fees in the amount of $975. Mr. King, are you going to be able to pay off any of these financial obligations upon being released from jail?
Yes, sir. I mean, not right away, but once I go back to work and get the ball rolling again, yes, sir.
Whenever you're released, you need to contact Miss Bonnie LaPrade at the courthouse. She is the court's collection officer. And I'm not sure if we have any cards there in the jail, but we'll need to get you one. And once you need to contact her so you can set up an arrangement to pay these things off. Failure to pay your fines, court costs, attorney fees will result in a warrant being issued for your arrest. So you need to know that, okay?
Yes, sir.
All right, Mr. King, I hereby remand you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with the bailiff. Good luck to you, sir.
Thank you.
Thank you, Your Honor. Okay. For your orders. Judge, we can do Mr. Bruner next if you'd like.
He's ready. All right, this is cause number CR 2041 and 42, State versus J. Michael Bruner. We're set today on a status of the competency report. The court has received the report of Dr. Ingram, has reviewed that, and has provided that to counsel for the defendant and counsel for the state. Go ahead.
Judge, I met Mr. Bruner after that, and I felt okay. I go back and forth, but I have received an offer from the state of Texas. I haven't had an opportunity to really discuss that offer with Mr. Bruner. I anticipate staying here after this proceeding is over with and doing that. And I think once I communicate with him and how the offer was obtained and what it exactly means and his position on that, I think I'll have a little bit better idea on kind of where he stands today as far as his mental state of mind. So I think I just need some additional time to see if we can make sure we get that accomplished.
So does that mean like an hour, like recall it here in an hour and we'll see
No,
what?
Judge, I think if we can just set it for maybe a couple weeks or a week, maybe a couple weeks.
Only concern I have is the longer he sits in the jail, I'm afraid he may languish and we may be right back where we started. Is there any chance that we could have that conversation today?
Yes, I could have it with him today. How about go
Or attempt conversation?
that we can do something today.
I'm not trying to put you in a hard spot. I
prefer to do it today if we can. If we can have some time, I'll see about talking to Mr. Bruner about resolving it a particular way, and we'll go from there.
if we can attempt it, that'd be great. And so we'll have him have a seat and we'll call Mr. Kronberger up, and I believe that's it. So on the court's docket. And so then we can just recess and give you some time. And if it's an hour, hour and a half, that'd be fine.
It shouldn't take that long, Judge.
Okay.
Thanks.
What?
Is this Mr. Kronberger?
Yes, sir. It's Mr. Kronberger, Your Honor.
All right, this is CR 2395. We're set for docket call today.
Judge, there's no, I've been in discussions with the DA's office about Mr. Kronberger's case. Mr. Woodward was able to give me an offer late, I guess it was yesterday, the day before. I have conveyed that offer to Mr. Kronberger, although I've not had an opportunity to really sit down with him and discuss kind of what the ramifications are or are not in taking that deal. I believe that this will be a plea, and I do believe that we're very close to getting it resolved and getting it accomplished. If we could have a couple weeks to just get that done, it is going to be an offer for time. And Mr. Kronberger understands that and understands that that's, he's not getting out of here immediately anyways. So if we could get a couple weeks, I think, to resolve this matter, I think we can do it.
Okay, we'll see Mr. Kronberger then for docket call on May 11th.
That'll be fine, Judge. Okay. Sign that. May the 11th, Judge?
Yes, sir.
That's all we have for Mr. Kronberger, I believe.
All right, thank you, Mr. Kronberger. We'll see you back on May 11th.
Thank you, sir. Judge, if I could have a brief moment to talk to Mr. Bruner.
Take as much time as you need. I mean, we're through the jail docket, so I'll just stand in recess and I'll keep it going. I'm going to pause I'm going to actually turn your camera and microphone off. So if you want to have that discussion there, then you'll just come back on when you're ready.
Okay, thank you, Your Honor. He's pretty volatile.
Your Honor.
Your bailiff?
Mr.
Yes.
Wood, for you.
Yes,
Well-
Deputy Aaron?
We're not on the YouTube, Judge, are we?
Yes, we are.
Okay,
I tell you what, do we need to go to a breakout room?
I think so.
Okay, give me just 1 second. All right, Deputy McPace, you're gonna need to unmute the device. All right, we are on the record. This is cause number CR 24-1, CR 24-2, State versus J. Michael Bruner. Court was going to entertain the status on the competency evaluation. The court has reviewed that, provided that to counsel, as I have said. Mr. Wood, I understand your concerns with Mr. Bruner. Mr. Bruner, I was going to consider letting him go home today. However, he was unwilling to communicate with the court. And so I believe that at the point, Mr. Wood, we either move forward with a hearing on whether or not you want to contest the psychologist or psychiatrist evaluation, or we move forward with a jury trial in this case.
Okay, Judge, I don't want to obviously put anything on the record at this point in time. I'm going to reevaluate the situation and make a decision and file something probably with the court in the near future on if I intend to contest the findings made by the psychiatrist in this matter. I'll also continue to talk to Mr. Bruner to see if his temperament changes at all. I think once I do that, I think I have a better idea on what I want to do going forward, Judge.
Okay, so what we'll do is we'll set this for docket call on June 15th. And if between now and then you make a election on that, you'll let us know, and then we can take that up on the 15th.
Sounds great. Thank you,
All right,
Judge.
thank you, Mr. Wood. Thank you, Mr. Bruner. Have a good day. I think a probated sentence might not be in the interest of justice in this case.
No, sir.
Seems a little dangerous to the community.
Judge, I would not discuss plea negotiations, but new information might control the state's negotiating at this point. Yes, Judge.
I'm going to stop